agreements just to show you how umbrella clauses work. At the same time, I realize this is certainly an off-talks given the composition of the panel, and people may be hesitant to talk about it. But I think so it just brings us much more closer to what the debate is, and even though we may not comment on these specific clauses in the bids and these controversies which are currently ongoing, they're not rendered decisions as such, but it's certainly useful. So to start out, I think so one dispute which has been capturing headlines for quite some time has been the Children's Investment Fund one. And it's pertaining to their dispute with Coal India, and how it's saying that the coal which is being sold by Coal India has been sold at an underpriced value, it's not through market mechanisms. Secondly, they're saying that there's a breach of fiduciary duty in as much that fuel supply agreements are being entered, which have trigger clauses, which penal provisions. Basically, if Coal India is not supplying to a private power company 80% of its fuel, then it even has to import it. Now, background to this is essentially a letter which is out in the public domain, which is put out by Children's Investment Fund, which details this and also highlights how a letter has been written by the Ministry of Coal to Coal India, which is a PSU. It states that this letter concerns instruction to Coal India stating that it revised the prices for coal, and it was subsequently done. And it says on the basis of this, there's a breach of fiduciary duty of Coal India towards its minority shareholders, and the constitution of Coal India is essentially 90% of it is with the government and 10% is with private shareholders, the largest block of which is managed by Children's Investment Fund. Now, subsequently, there's a notice dated 27th March 2012 by which two specific BITs have been invoked, and this notice has been sent by Children's Investment Fund to the Union. And there's Article 9 of the Cyprus Treaty and there's Article 9 of the UK BIT. And essentially, if you go towards the end of this notice, there are three clauses which are mentioned. The first one is Article 3 on fair and equitable treatment, Article 5 on expropriation, and these are both specific as we were talking about earlier. However, it also goes back to the umbrella clause under Article 3, only present under the UK treaty. Here, the Cyprus one does not contain that for some reason. So this also brings us to the question and the discussion we were having as to does an umbrella clause really dilute the existence of other more specific provisions in a treaty itself, and whether it's advisable, is it essentially only a deeming provision, and in the absence of it, what happens? Now, also going forward with this, what happens in terms of the private adjudication that Children's Investment Fund is also taking into account? It's independently also pursuing remedies, even though not under contract, but what I do anticipate, it may be filing a petition for mismanagement and oppression. And this is clearly an independent remedy, not so much in the terms of a contract, but at least it's a remedy which is fairly distinct from the one which arises under the BIT, which is, and even under the umbrella clause. Now, the second case which I'm discussing is the Vodafone one. I'm just throwing it out there. And in fact, in Vodafone, the facts are more or less with most of us in this room. And after the budget has been passed and the retrospective amendment has been made, and this is all in anticipation. Vodafone is saying that it may get a tax notice. The papers also say that the IT authorities are confirming in 2 days they may get it. Now, subsequently, Vodafone is saying that it will reserve all its rights and all avenues to contest this, and this also includes the Netherlands BIT. Now, the Netherlands BIT, more or less, it's from some articles I've seen, and also the BIT itself, it specifically excludes any any national treatment or MFN for tax. This is Article 4.4. So I'll just read it out. The provisions of paragraphs 1 and 2, which essentially lay out national treatment and MFN, in respect to the grant of most favored nation, shall not apply to privileges with either contracting party. A call done in this case, but See, this just brings to focus and more relevance and umbrella clause. If there are such exclusions in terms of MFNs or national treatment, anything like that, or expropriation also. So I think so. What we are grappling with here is the specifics in the bit and also how it's framed. And these two cases will, towards a large extent, contextualize this debate for us. Thank you.
I want to go back a bit. Maybe we can go back and discuss two cases through. I want to go back to the discuss the views that all of you had expressed on the wide interpretation and the narrow interpretation. Frankly, I did not have a very crystallized view as such, but I kind of tend towards the middle ground, not because it is convenient, but because I suppose any view that we take, whether it is a wide view or a narrow view, much depends on the facts of that particular case, not only about how the clause is drafted, but also the other circumstances of that contract in question, the contractual breach in question, and so on and so forth. So before I give my personal view on which side or what kind of interpretation that I favor, I would like to give a brief on my assumptions of that view. So I'm assuming that the umbrella clause in question is what Mihir read out in the beginning. Any obligation, as in observe any obligation that the contracting state may have assumed with regard to the investment, assuming that is the umbrella clause, and assuming there is a contract between the state and an investor, and there is provision in that contract which provides for all disputes related to that particular contract to go to a specific dispute resolution mechanism, if that is also another fact that is in consideration. And the treaty provides for an investor-state dispute mechanism also. So these are the three specific facts in this particular hypothesis, and if I were to take a view on which interpretation that I would rely on, I would go for the middle path as I mentioned earlier. The reasons for this view are as follows. Firstly, I do not think that SGS Philippines, the first part, I do not kind of support that view, because the umbrella clause has to be read based on the Vienna Convention as to how it should be interpreted, and we should keep the objects of the bilateral treaty in mind. It is an investment treaty. It is supposed to favor investments. It is not supposed to be interpreted in favor of one particular contracting party or contracting state just because there is some kind of ambiguity. So bearing in mind those principles of interpretation, I would think that not every breach of any obligation in a contract would directly bring it to a treaty claim or a matter which can be settled by the provisions of arbitration in the treaty. So I would assume and I would think that a very wide interpretation is not something which I would support. So in this case, assuming the facts here were such that there was just a mere contractual violation which did not amount to any other treaty violation. So for example, if it was something like invoices were not paid or something like that, and it's nothing to do with any other standard provided in the treaty that was violated, then I have the view that you cannot give a wide interpretation to that, no matter what the intention of the parties could be. So because the clause by itself does not give that kind of an inkling on the intention. As far as the narrow view is concerned, I also do not subscribe to what was proposed or propounded in the SGS Pakistan decision. It is not like one would nullify the entire clause and say that it is too wide and therefore would not give it any meaning. I assume that every clause has to be given some kind of meaning, so it is for the tribunal to find out what exactly could have been the intention of the parties when they inserted that particular clause in the treaty. So to find out what could have been the intention, the only option that I kind of came about, which was appealing to me, was that proposed by the decisions such as El Paso. I think when the state entered into the bilateral investment treaty, it was, as Vikas pointed out, wearing the hat of a sovereign. So the clause where it says, I will observe every obligation, basically means that I will not use my sovereign powers to interfere with any of the obligations that I might have contracted with an investor. It does not mean that if I violate each and every any obligation of a contract, you can come and treat it as a treaty claim. So I think we'll have to bear in mind and be conscious of the fact that the bilateral investment treaty is entered into by sovereigns, and they're not completely renouncing all the sovereign rights when they enter into the treaty. So I would think that only certain kind of contractual claims which arise because of interference by the state in its capacity as a sovereign, or claims which are so intertwined with the violations of other minimum standards or other standards and agreements in the bilateral investment treaty could come under the purview of the protection of the umbrella clause, and not any and every violation of the treaty that the state might enter into. So that's my view on the way I would interpret an umbrella clause, bearing in mind these facts. And as far as whether the contract should have been with the state or with the sub-entity of the state, I think it has to be with the state. I think the way it can't be lifted, a PSU or a state enterprise entering into a contract is completely different from the state entering into a contract. So it has to be a concession contract or something of that nature rather than a commercial contract with a state enterprise. And lastly, as far as the dispute resolution mechanism that is there in the individual contract and the dispute resolution mechanism that is there in the treaty, I am very convinced that the specific overrules the general, for one. And secondly, since most probably the treaty came first and the contract came next, it is only reasonable to assume that if the intention of the parties was to directly escalate all contractual matters to a treaty matter, they would have stated so in the contract. So it is kind of unthinkable as to why two sophisticated parties would enter into a contract and say that we would go for this domestic arbitration or this domestic dispute resolution process when they're well aware that they all along intended that it has to be under the umbrella clause through a very accelerated, more sophisticated form of arbitration mechanism. So going by the intention of the parties and going by the rule of specific overrules the general, I would think the second part of the Philippines judgment is correct, that they did defer to the dispute resolution mechanism provided in the contract, because and that's that. I think another point was raised as to whether unilateral changes in the law and stuff like that would also come under the umbrella clause. I suppose when you, it again depends on the language of the umbrella clause, but in the clause that we are looking at, any obligation will not be any laws or any sovereign legislative powers that the sovereign might have. So in the absence of a very specific stabilization clause, I would assume that unilateral declarations or even changes in the law will not come into the scope of an obligation. So that's my view.